By the way, we're going to talk about Dr. Benjamin Rush, the only physician who was actually one of our founding fathers and signers of the Declaration of Independence, as we go through this jury trial today. But just so you see, the Fabians really have control over the political system to a large degree, at least that philosophy, especially the private, secretly run Federal Reserve Bank that the Supreme Court somehow declared to be a quasi-public, quasi-private agency. Well, I've got news for you. There is no provision in the Constitution for such a monstrosity or institution to exist. But when the schools, the colleges have their secret societies, Skull and Bones or whatever, and all the politicians and judges come from these organizations, what do you think is going to happen? I want to know what you have to say in the comments. So let's let Mario finish.
Even the Conservative Party now, if you told someone from the early 1900s what the Conservative Party stands for, the policies that they enact, they would say, well, that's the Labour Party. So why am I talking about this? Well, because right now the UK tax take is around 35 to 37% of GDP.
It's ridiculous.
And yes, the broader trend is that Britain's tax burden is now at or close to the highest level since World War II.
And it doesn't help that Britain allows illegal aliens to flood into their country, the vast majority of whom immediately go on welfare and have babies, right? And they're going to be voting for the political class who gives them free stuff. So ultimately, my belief is, like the Fabians or Fabians, like these societies, I believe to be secret societies to a large degree, at least there are meetings like the Warburgs, for example. I believe their goal is to recreate a noble class and a wealthy class where they control all of the serfs. And they do that by importing low IQ people into their country from places like sub-Saharan Africa, the lowest IQ in the world, where they're easier to control because they're incapable of critical thinking. And in that way, they can replace the critical thinkers in their countries who don't want this type of thing to happen by use of democracy, which is where 51% of the population can steal and destroy the rights of the 49%. And that's why our founding fathers wanted America to be a constitutional republic, not a democracy, where the government was bound by the chains of the Constitution. So let's get into the show now. Let's get into the case in chief. So again, we're going to present this as if we're on trial. We're putting Big Pharma and the Rockefellers on trial today, and we're going to start with the Flexner Report, with the Carnegies and the Rockefellers and their takeover of the medical schools and traditional medicine. So ladies and gentlemen of the YouTube jury, court is now in session. I am natural law attorney Michael Ehline, and I appear before you today as the prosecutor in this criminal trial of the people versus the engineered medical monopoly. Seated at the defense table are the FDA, the CDC, and the institutional forces that still proclaim, quote, only FDA approved is legitimate medicine. Everything else is dangerous quackery. The evidence will prove beyond a reasonable doubt that centuries of natural healing wisdom rooted in ancient traditions was deliberately destroyed by the Rockefeller interests and allies through the 1910 Flexner Report and the importation of the Prussian education models designed to produce generations of non-critical thinkers. We will further examine the Tartarian civilization's advanced knowledge, the suppression of alchemical healing in monoatomic gold and colloidal silver, and a host of lost technologies with ancient arcs. We begin with the founding vision that was betrayed, and we're going to use the rules of evidence and objections in this trial under Texas rules of evidence and California rule and the California Evidence Code. And because of that, all exhibits must be relevant. Okay, so I'm going to lay a foundation for you the way that an attorney would. Texas Rule of Evidence 401 and California Evidence Code Section 210, basically that all these exhibits and their probative value must not be substantially outweighed by unfair prejudice. Texas Rule of Evidence 403 and California Evidence Code Sections 352. The defense will repeatedly object on hearsay grounds, out-of-court statements offered to prove the truth of the matter asserted. I anticipate and will overcome these objections as follows. The public records exception. The Flexner Report and government medical histories qualify under Texas Rules of Evidence 803 sub 8 and California Evidence Code Section 1280. Is official records. I'm also going to use the ancient documents exception. Documents 20 plus years old. under Texas Rules of Evidence 803 sub 16, or 30 plus years old under California Evidence Code section 1331. And I'm going to establish their authenticity as admissible.